In this video, we will study interpretation of statute. Important question. That first question is, what is literal interpretation? Explain. The literal rule is the primary rule which takes precedence over the other. Under this rule, the judge is asked to consider what the legislature actually say rather than considering what it might mean. Words and phrases should be construed by the court in their ordinary sense, and the ordinary rule of grammar, punctuation, should be applied. In order to achieve this, it is up to the judge to give word in the legislation their literal meaning. That is the rule which is on the literal meaning. Even if the effect of this is to produce what might be considered as an unjust outcome, effect should be given irrespective of its consequences. Example, fish service, bail case. The shopkeeper had a flick knife on his shop window with a ticket bearing word ejector knife. Under the Restriction of Offensive Weapon Act 1959, Section 1, Subsection 1, it was illegal to manufacture, sell, hire, or offer for sale or hire or lend to any other person any knife. This is illegal to sell this type of weapon. The claimant, claimant alleges that the defendant shopkeeper had contravened Section 1, Subsection 1 by offering the flick knife for sale. It was held that the court displaying the knife was merely on the invitation to treat, not an offer for sale, thus no liability accrues to the salesman. The lack of the word exposing for sale in the Restriction of Offensive Weapon Act 1959 suggested that only a true offer would be prohibited by the Act. This rule can be explained under the following head. First one, natural or grammatical meaning. First rule of interpretation is common general use of that word, grammatically used, or natural meaning of that word is most important. The word of the statute should first be understood that there is a natural, ordinary, popular in sense and general in use, and phrases and sentence are to be construed according to their grammatical meaning, unless that leads to some absurdity or object of the statute suggests the contrary. If any contrary on that word, then we go to further. Otherwise, normal, natural, or grammatical meaning is applicable. It is there is no ambiguity, and the intervention of the legislature is clearly conveyed. The court should give effect to it, not try to amend it. Ramtar Ramavatar with sales tax officer. The act of the sale of vegetable does not attract sale tax. Therefore, when an assistant sale tax officer wanted to tax the sale of bitter leaves, the salesman that Ramavatar selling that bitter leaf, and he saying that bitter leaf is under the category of vegetable, but then salesman filed the charge against that Ramavatar, and then court say that a vendor objected on the ground that bitter leaf was a vegetable. He claimed exemption from the tax. To advance his argument, he relied on the dictionary meaning of the vegetable in the short Oxford Dictionary and textbook of botany. Supreme Court did not accept the scientific or dictionary meaning of the word vegetable and observed that it must be construed not in any technical sense, nor from a botanical language point of view, but an understand in the common parlance. It held it has not been defined in the act and being a word of everyday use. Bitter leaf, bitter leaf in the everyday use. It must be construed in its popular sense, meaning that sense which people conversant with the subject matter with which the statute is dealing would attribute to it. It is to be understood as understood in the common language. In this point, in this view, bitter leaves was not vegetable, that is said by Supreme Court, but as a condiment, that is masala. Not being a vegetable, it could not enjoy exemption from the sale tax. It not enjoy exemption from the sale tax. The judgment laid down the basic principle that a vegetable is one that in the market parlance is known as such. This is the definition of the vegetable for fiscal law, but not so for student of botany, who would regard bitter leaf as a vegetable. So the definition depend upon who asks the question. For a botany student, bitter leaf is a vegetable, but not for a tax collector. For a tax collector, is a condiment and applied a tax on it. Therefore, the sale of bitter leaves was liable to be sale tax. Second one, exact meaning compared to the loose meaning. What is the exact meaning? It is presumed that words used in the statute are used correctly and exactly and not loosely. Correctly or exactly word should be used, not loose word should be used in the statute. And inexactly not to be used, only exactly or correctly used should be used in statute. Example, the exact meaning of the word contiguous is touching, and whereas it is loose meaning is neighboring. Every word has a secondary meaning too, that is double meaning of that words. Thus, court should be carefully not to mix up secondary meaning with the loose meaning. If secondary meaning pointed to that meaning, which statute means that preference should be given only that primary meaning of that word. Third one, technical word in technical sense. First one, special meaning in trade, business, etc. According to this word are to be understood in their subject matter. Thus, in the case of legislation relating to a particular trade, business, profession, or science word having a special meaning in this context are understood in that sense only. Example, the term waste or non term applied to a ship, and nobody would think of this their meaning to the waste of a person when used in the act which deal with ships. Second one, legal sense of the word. When word acquire a technical meaning because of their consent used by legislature in a particular sense, or because of their authoritative construction by superior court, they are understood in that sense only when used in similar context in subsequent legislation. Second question, that is very important question, what is statute? Mean definition of the statute. What is why interpretation of statute, why it is so important? Explain the external aid of interpretation. There is two aid of interpretation. First one is internal and second is external aid of interpretation. Here we will study about the external aid of interpretation. A statute is will of the legislation. This is will of the legislation. It derived from the Latin word statutory, means to be made to sit up. It is a formal expression in writing of the will of legislature. It is usually called an act of the legislature. A statute, unless it is expressed to a duration that is temporary, never dies, though it may be amended or repealed. There are aids for interpretation which are not part of statute, and these are known as external aid. These external aids are relevant only when the language used in statute is not clear, two meanings are possible. When there is a two meaning of possible, then external aid of interpretation are used. First one, dictionary. Usually a word would be defined under the definition clause of the statute, and the said word will have to the same meaning for that word whenever it occur again in the act. But when a word is not defined in the act itself, it is permissible to refer to the dictionaries to find out the common parlance in which that word is used. First one, the primary is the common parlance of or general use of that word. What is the meaning of that word? But again, dictionary will have various meaning for that one word, and in selecting one out of the various meaning, regard must be given to the context in which it is used in the act. Then there is so many meaning in the dictionary. Then what we will choose? We will choose only the context in which it is used in the act, because the expression must take color from the context in which they appear. If plain reading of the provision bring out what was indeed and there is no ambiguity, then dictionary meaning of a word is not considered. Ram Rautar versus Assistant Cell Tax Officer. We already read about in previous question. Rautar versus Assistant Cell Tax Officer case. The act of the sale of vegetable does not attract cell tax. Therefore, when an assistant cell tax officer wanted to tax the sale of bitter leaves, a vendor objected on the ground that bitter leaf was a vegetable. He claimed exemption. To advance his argument, he relied on dictionary meaning of the vegetable in the Shorter Oxford Dictionary, a textbook of botany. The Supreme Court did not accept the scientific or dictionary meaning of the word vegetable and observed that it is must be construed not in the any technical sense known from a botanical point of view, but as understand in common parlance. It held it is not being defined in the act and being a word of everybody use. It must be construed in its popular sense, meaning that sense which people conversant with the subject matter with which the statute is dealing would attribute to it. It is to be understood in common language only. In this point of view, bitter leaf was not a vegetable but a condiment. Not given, not being a vegetable, it could not enjoy the exemption from the sale tax. Second one, foreign decision. In pre-constitutional period, reference to English decision was a common practice. Despite warning by the Privy Council, the practice is continued even now to extent. There is a one qualification attached to the assistance of foreign decision. The prime importance is always to be given to the language of the relevant Indian statute, the circumstances and the setting in which it is announced to the Indian condition where it is applied, and there is always an element of risk in taking ready and hasty assistance from the foreign decision. Parliamentary history. The Supreme Court does not use the aid of parliamentary history in resolving question of construction, but it used within it circumspect limit only in resolving ambiguities. Bill or debate on a bill in parliament are not admissible for construction of the act which is ultimately enacted. The speech only shows the subjective intent of the speaker, but it cannot reflect the inarticulate mental process lying behind the majority vote which carried the bill. Nor it reasonable to assume that the mind of the legislature were one of accord, but in Indra Sani versus Union of India, Supreme Court referred to Dr. Ambedkar's speech in the Constitutional Assembly for the interpreting the expression backward classes of citizen which is not defined in the Constitution. Second one, statement of the object and reason. It can be referred only for the understanding the background, the antecedent state of the affair, the surrounding circumstances in the relation of the state of affair, and the evil which statute was sought to remedy. It cannot be utilized for the purpose of restricting and controlling the plain meaning of the language employed by the legislature in the drafting in a statute and excluding from the operation such transaction which it plainly cover. Third one, commission and inquiry committee, report of commission or inquiry committee precedent the introduction of a bill which also been referred to as an evidence of historical fact of the surrounding circumstances or mischief or evil intended to be remedied and at time for interpreting the act. In Shodra Devi case, in which income tax inquiry report was referred, and in Express newspaper case, the press communication report was referred. Fourth one, parliamentary debate. This can be used an external aid in interpretation, but it is used is limited. Parliamentary debate use is limited, or it is used as a external aid of interpretation. Fifth one is letter. Letter written by law minister cannot be used as an aid. It cannot override the statutory provision. Fourth, historical facts and surrounding circumstances. The court is at library to look into the history of the law, the circumstances which existed and which led to the passing of law, the evil which is intended to remedy, where it is important to ascertain ancient fact of public nature. Recourse to historical work, document and treaty may be taken. Fifth, textbook. Textbook can be used to ascertain the true meaning of enactment, but it is discretion of the court to accept or reject the view given in the textbook. That is famous case Kesavanand Bharati versus State of Karnataka is one such case where a large number of textbooks were quoted in arriving the decision. Sixth one, subsequent social, political, economic development and scientific invention. This can be discussed under the following heading. Journal Act. A statute may be interpretation to include circumstances or statute situations which were unknown and don't exist at the time of enactment of statute. When a change in social condition produce a novel situation which was in contemplation at the time when a statute is first enacted, there can be no prior assumption that the enactment does not apply to the new circumstances. Development in science and technology must be taken into consideration while interpreting an ongoing statute. Science and technology development must be taken into care. Example, it has been held that telephone is a telegraph within the meaning of that word, and the Telegraph Act 1863 and 1869, although telephone was not invented in 1869. Second one, Constitutional Act. A constitution is intended as an enduring instrument, not only designed to meet the need of the day when it is enacted, but also need of the altering condition of the future. Thus, the language of the Constitution is given a liberal construction so as to include which is it embed the future development in various fields of human activity and not just restricting the language of existing thing at the time of passing of Constitution. Constitutional provisions are required to be understood and interpreted with an object-oriented approach. It should not be interpreted in a narrow and pedantic sense. Every provision should be read harmoniously and purposely and should not be render another provision redundant. The best example can be taken the Article 21 of the Constitution, which provide no person shall be deprived of his life and personal liberty except according to the process established by law. Now to the Article 21, a whole lot of human activity were deduced from Article 21, like right to mean of livelihood, privacy, education, speedy travel, etc. Third most important question, state the effect of repeal of perpetual and temporary statute of interpretation. Effects. Effect of expiry of temporary statute. When the duration of the statute is for a short specified period, it is a temporary statute. After a temporary statute expire, it cannot be made effective by merely amending the same. Revival of the expired statute can be done only by reenacting it is on similar term on expressly saying that the expired act is herewith revived. The effect of the expiry of temporary statute can be discussed under the following subheading. First one, legal proceeding under expired statute. After the expiry of an act can be legal proceeding under the act can be initiated and continued. If that act has a saving clause, its effect would be similar to section 6 of General Clause Act, which say repeal of the state statutes should not affect the legal proceeding. But if such saving clause is not present, then the proceeding started under the temporary statute would terminate as soon as the statute expires. Thus, in the absence of saving clause, no person can be prosecuted, convicted under the expired act, and the ongoing proceeding will be terminated at once with the expiry of temporary act. Raila Corporation, with Director of Enforcement, that is case about that legal proceeding expired statute. Second one, notification, order, rule, etc. made under temporary statute with the expiry of temporary act. Any notification, ordered, or rules issued under it will also come to an end and cannot be revived even if the provision of the expired act is reenacted. If that is reenacted, then it is for in temporary nature. Third one, expiry does not make statute dead for all purpose even without the saving clause. The expiry does not make the statute dead for all purpose. The nature of the right and obligation under the act has to be considered in determining whether such right and obligation are continued after the expiry of the act. And number, State of Odisha versus Bhupender Kumar. It was held that a person who has been prosecuted and sentenced during the continuation of temporary act for violating its provision cannot be released before he serve out his sentence, even if the temporary act expire before the expiry of full period of sentence. Fourth one, repeal by temporary statute. If a temporary statute repeal an existing statute, the question which arises is if the repealing temporary statute expire will be repealed statute revive. This will depend on the construction of repealing statute. Mode of repeal: express repeal, repeal by implication. Repeal of the statute may be express or by necessary implication. There is no reason to restrict the meaning of the word repeal merely to an express repeal and to exclude the implied one. Express repeal of a statute is usually made by stating that earlier statute or a particular provision therein is thereby repealed. Usually, enactment repeals are maintained in a schedule attached to the repealing statute. Such express repeal need to be construction of later statute. When the object is to repeal only a portion of the act, words shall be omitted are normally used. The legislative practice in India shows the omission of a provision is treated as amendment, which signify deletion of that provision and is not different from repeal. Substitution thus combine repeal and fresh enactment. Sometimes the expression used in later statutes runs. Number one, A. All provisions inconsistent with the act are repealed. Second one, all fact and part of the act are conflict with the provision of the act are hereby repealed, or all law and parts of the law are conflict herewith are explicitly repealed. Provision of this character leave the question open as to what law are inconsistent and not intended to be so repealed. The rule must not be pressed to for a special enactment and a subsequent general enactment are absolutely repugnant and inconsistent with one another. The court have no alternative but to declare the prior special enactment as repealed by subsequent general act. In all such cases, the legislative intention rather than grammar or letter of enactment is determined the factor. If the intention is found to be swept away all previous order and to establish one rule for all belonging to a class of a person, that will be sufficient to get rid of all previous special provision. There is no doubt that repeal by implication is just as effective as by express word. The general rule is that when you have an act of parliament enacting particular provision and in a subsequent act there are provisions which are inconsistent with provision of the first act, both enactment cannot stand together. The enactment in the second act stand and repeal the enactment in the first act. Of course, from the necessity of the case, it is are implied and not an express repeal. where two statutes passed in the same year appear to be repugnant, that which was passed latest must prevail. Repeal by implication is only affected when the provision of a later enactment are so inconsistent with or repugnant to the provision of an earlier one that the two cannot stand together. A prior general act may be affected by subsequent particular and special act of subject matter of the particular act prior to it enforcement was being governed by general provision of the earlier act. In such a case, the operation of the particular act may have the effect of partially repealing the general act or curtailing its operation or adding condition to its operation for particular cases. Famous case in municipal board Brayley with Barth Oil Company. The state government has framed rule regulating the levy of octroi in general by all municipalities. Thereafter, rules were framed by state government for levy of octroi by Bareilly Municipal expressly provide that the new rule which apply in separation of the existing rule. It was held that there was a deemed repeal of the earlier rules in respect of Bareilly municipality. Resumption against repeal. There is a presumption against repeal by implication. The reason for the presumption is that the legislature, while enacting a law, has a complete knowledge of existing law on subject matter, and therefore, when it does not provide a repealing provision, it give out an intention not to repeal the existing legislation. The burden to show that there has been repeal by implication lies on the party asserting it. Court can lean against implied repeal if, by any fair interpretation, both the statute can stand together. There will be no implied repeal. If possible, implied repeal should be avoided. Where two enactments are entirely affirmative and identical, no question of inconsistency can be raised. Case of repeal by necessary implication. Hence, a statute is repealed by implication in the following case, namely: Number one, if its provisions are plainly repugnant to those of the subsequent statute, if the two standing together would lead to wholly absurd consequences, if the entire subject matter of the first is taken away by the second. Consequences of repeal. Journal. Under the common law rule of consequences of repeal of the statute are very drastic, except are to be transaction past and close a statute after it repeal is a completely obliterated as if had never been enacted. The effect is to destroy all incolate right and all cause of action that may have arisen under the repealed statute. Therefore, leaving aside the case where proceedings were commenced, prosecuted, and brought to finally before the repeal, no proceeding under the repealed statute can be commenced, so continue after the repeal. Another result of repeal under the common law rule is to revive the law in force at the commencement of the repealed statute. Thus, if one statute is repealed by second, which is turn is repealed by a third, the effect is to revive the first statute unless a contrary intention is indicated in the third statute. The confusion resulting from all these consequences give rise to the practice of inserting saving clause in saving of rights acquired. The effect of clause C and E, C to E of section 6 General Clause Act is a speaking briefly to prevent the obliteration of statute in spite of its repeal, to keep intact right acquired and accrued and liability incurred during its operation, permit continuation or institution of any legal proceeding or recourse to any remedy which may have been available before the repeal of enforcement of such right and liability. Thus, offence committed during the continuation of statute can now be prosecuted and punished even after it repeal, a course which would not have been possible under the common law rule, complete obliteration of a repealed statute. The distinction between what is and what is not a right preserved by the provision of the Section 6 General Clause Act is often one of the great fineness. What is affected by repeal of the statute is a right acquired or accrued under it, and not a mere hope of exception of or liberty to apply for acquiring a right. A distinction is drawn between a legal proceeding for enforcing a right acquired or accrued as a legal proceeding for acquisition of a right. The former is saved whereas the latter is not. The question whether a right is acquired or a liability incurred under a statute before its repeal will in each case depend on the construction of the statute and the effect of the particular case. The right of an injured third party to recover damage against the insurer of a motor vehicle will be an accrued right on the happening of the incident resulting in the injury and will be enforceable against them even after repeal the enactment creating the liability even though the process of quantification is not complete before the repeal. Revival. Under the English common law, when a repealing enactment was repealed by another statute, the repeal of the second act revived the former act. But this rule does not apply to repealing act passed since 1850. And now, if an act repealing a former act is itself repealed, the last repeal does not revive the act before repeal. After that, 1850, unless word are added reviving it. The present rule is result of the statutory provision introduced by the Interpretation Act 1889. But though we are not bound by the provision of any English statute, we are still apply the English common law if it repeal appears to be reasonable and proper. But it may be noted that even according to the common law doctrine, the repeal of the repealing enactment would not revive the original act if the second repealing enactment manifests an intention to contrary. The common law rule revive has been abrogated by section 6A and 7 of General Clause 1897. The result therefore is that if one act is repealed by a second, which again is repealed by a third, the first act is not revived unless the third act make an express provision to that effect. As regard revival of enactment, section 6A cover what is more emphatically declared by section 7, but the latter is limited in operation of enactment, whereas the former is wider in operation, will prevent the revival of many other matters. Example, the revival of the void contract of common law when a provision is repealed by substitution of another provision in its place and the act making the substitution is declared invalid. The question of revival of original provision require consideration of whether the act has been declared invalid for want of legislative competence or on other ground. When a temporary statute affects a repeal of an existing statute, a question arises whether the repealed statute revive on the expiry of repealing statute. Fourth question, explain the common law rule relating to statute affecting the crown or state. The common rule, the rule of common law. First one, a statute are enacted for the subject and not for the king. Thus the crown is not bound by any statute. There is one exception to the above rule. If the intention of the legislation is clear that the crown has to bind by the statute, then he will be bound, that crown will be bound by necessary implication. In such case, by giving his assent, the king agree to be bound by it. B. Crown can be bound by express word or necessary implication. C. In Bacon abridgment, it would stated that the crown is bound by statute which deal with the public good advance of religious despite the king not being expressly mentioned there. But this view ID not approved by modern writers. D. To know if the crown is bound by necessary implication, the safest way is to read the statute as a whole and ascertain the intention of the legislature. Famous case, Bombay Provinces was Bombay Municipal Corporation for common law of reliance. In this case, the question was whether the provision of the Bombay Municipal Act 1888, which authorized the commissioner to carry out water means and municipal drain through under any land within the city, The Bombay High Court concluded that even the government land within the city was subject to the statutory authority of the corporation to carry out water mains because of the legislation cannot operate with reasonable efficiency unless the Crown is bound by the necessary implication. The Privacy Council, however, overruled the decision and held that there is no authority which gives support to the above interpretation. Extent of rule. From where to the rule extended. The provision of that the Crown is not bound by statute extend to the following class of people. First one, sovereign personality. Second one, servant, oblique agent of the Crown directly. Third one, the person who, though not strictly servant agent of the Crown, are considered to be consumingly consumed. These are the persons who are independent of Crown, perform to a limited degree of regal government functions such as administration of justice, the carrying of war, making of treaty, etc. Tamblyn versus Hinfold, old famous case. Rule in India. The common rule was that the Crown is not bound by statute unless named expressly by necessary implication. This was followed in India before or even after the Constitution. But soon this rule was overruled in state of West Bengal with Corporation of Kolkata, in which the court held that a general act applied to citizen as well as state unless it expressly or necessary implication exempt the state from its operation. Fifth question. Every statute is prima facie prospective unless it expressly or necessary implication made to have retrospective operation discussed. Every act has a date from where it start functioning, called as the commencement clause. The commencement of an act means the day on which the act come into force. Generally, a central act come into operation on the day it received the presidential assent when the president signed, and on that date that act came into force. Before that, that will called bill. A state act came into force on the day where the assent of the governor. When governor signed on that bill, that it become act, or the president is the first published in the official gazette of that state. Unless an act is brought into force by legislative authority, it cannot said to be in operation. Generally, the whole act is brought into force on a specified date. Even different part of the same act may be brought into force on different date. If the statute is pending for a long time with the government without being passed, a writ of mandamus can be filed against the government. The court may direct the government to consider the question whether the statute or the provision should be brought into force or not. A bill does not come into force unless it takes from of an act. There are two types of operation of statute. First one, prospective operation. Second one, retrospective operation. Prospective operation. Prospective means present and future. Prospective application means that an act start its validity from the date of it coming into force. It will apply for all present and future event until and unless it is repealed. The general rule is that statute which enacted as a prospective application. General rule is the only the prospective operation. It applied in the future on present date or in coming future times. And the retrospective operation, that is all about the past. Retrospective application means an act which apply to the past event and also to the present events from the past to present. All statute are prospective in application, but not all statute have a retrospective application. The cardinal principle of the construction is based on the Latin maxim novo constitutiono futuris formam impronio debt non praeteritis. A new law ought to be regulated what is to be followed and not the part. It is always understood that a statute applies to the fact and circumstances which occur after the existence of the statute, unless the legislature intended to apply it retrospectively. If the legislation apply retrospectively, then only that act apply to the first act. For the statute to apply retrospectively, it has to be expressly stated by the legislature. There are five general principles of retrospective operation. They are as follow. First one, the power to make retrospective law. Second one, statute dealing with the substantive right. Third one, statute dealing with procedure. Fourth one, recent statements of the rule against retrospectively. Fifth one, language not always decisive. Power to make retrospective law. Power is vested with the Union Parliament and state legislature. These two have power to legislate a statute to the retrospective and prospectively. By stating that a particular act is retrospective in nature, the legislature try to bring all those events which took place prior to the commencement of the said act within the scope of that act. Usually, retrospective effect is given to the curative and validating statute to cure the defect which existed before the passing of that act. Example, declaratory act, procedural law such as CRPC, CPC, presumption as to be abatement of suicide by married women under section 113A of the Evidence Act 1872. Statute dealing with the substantive rights statute. Statute dealing with the substantive rights statute provision which deal with the right in existence cannot be applied retrospectively. It is a cardinal principle that every statute prima facie is prospective unless it either expressly or impliedly marked as retrospective. This is based on the maxim nova continuis futuris norman imponere debit non practitionis. A law ought to regulate what to follow and not the past. The rule against the retrospective application lies only with the respect of vested right is not existing right. Statute dealing with procedure. The rule of retrospective operation can be applied to procedural statute, CRPC, CPC, law of evidence, etc. It is prevented that in procedure statute, no person has vested right in procedure. He only has the right to prosecution prescribed for the time being. It is only an existing right which start from the initiation of the case and end upon the final verdict. Example 2, Section 45B of the Employee State Insurance Act 1948. The section empowered the Employee State Insurance Corporation to recover arrear of the contribution from the employer as arrear of land revenue. Therefore, this being procedural in nature can be applied prior to the commencement of this section. Recent statement of the rule against retrospectively, unless the Parliament clearly indicate retrospective aspect, a statute or provision cannot be presumed as retrospective in nature. The intention of the legislature is very important. Language not always decisive. More important to the tense cannot be given to know whether a statute proviso has retrospective application or not. If the section has word like of a person has convicted patents, we cannot assume that it also speak about prior conviction. Similarly, the word like he made, has seized, he failed, and has become many specify event happening before or after the commencement of the act. What is important too is to find out whether such event would place fall within the scope of that act. In next video, we will discuss about explain the basic principle of legislation. Very important question from examination point of view. If you will listen 2-3 times this video, you are able to write in examination and clear your law question very easily. Thank you for watching.